Sorry, we're running a little late. Are you guys ready though?
Sure. A little bit earlier. It was something. Geographical realities of what that little tiny community was, and that turned it into an alien planet, like it doesn't connect to any. You know what I mean? Like it's its own new thing, and like. You see like these embryonic forms of social contract in there. I mean, they're weird, and they're also there's violence that's right in the face of it too. And tension between it. Matter of fact, that's those terms change. I mean, yeah, I'm trying to digest it in full. That's wow. So I was thinking of some kind of cushy by comparison, I'm sure. Absolutely. But now, you know, I'm familiar with that. And so, I get the idea that maybe you're not a guy who sets out at the end of his life and you're just saying, all right, here's the
all right. Executive report is now in session. The Honorable Vice Chair Campbell presiding.
That's okay. Good morning.
Good morning.
Be seated. Most of the time. I did call once. I was like, it won't turn on, it won't turn on. She's like, there's this little button over here. Be like, it's been a hard couple of weeks. All right, I have a motion.
Your Honor, before we start, I've had some requests about the live stream for this hearing from various government agencies, law enforcement that are interested in watching this hearing. They wanted to know if the live stream would be on.
It's already on.
Oh, that's what I just wanted to check, make sure it was there.
Morning.
Morning.
We filed an emergency motion for protection this morning. I want to outline a little bit of the facts behind that. A couple weeks before trial, a file transfer link was sent to the plaintiff's attorneys, specifically Mr. Bankston. That link linked up a lot of files that shouldn't have been connected to it. Mr. Bankston immediately recognized that the files contained therein were confidential, attorney-client privilege, and contained medical records of people, a whole variety of things that should not be turned over. And he pointed that out to me, and I responded to him. He said, I take it this was sent in error. And I responded to him and I said, it has been sent in error. Please disregard the link. I will work on preparing a new one. I believe, based on that communication, that that's what was going to occur. I mean, we have a situation here which is akin to me mistakenly giving him the key to a room, and you know, he opens the door to the room, and instead of finding what he expected to find, he sees other doors. One door is marked confidential medical records. Another door is marked attorney-client privilege. Another door is marked attorney work product. Another door is marked confidential communications. And he recognized that and told me, I don't think he meant to give you this key. And I said, please throw it away. And apparently at some point thereafter, he said, you know what, I kind of really like to see what's behind those doors. And so he took that key and he went back in and he unlocked and went into each one of those doors. And that's why we're here seeking protection under the Texas Rules of Civil Procedure, as well as the court's confidentiality order. We are very concerned about the records that have been disclosed, particularly the medical records. It's very, very concerning for us. And that's why we are asking for the relief that they return all the documents, that they destroy any copies that they have. Another thing that's concerning, and I have to, I hate to be put into this position by the conduct of plaintiff's counsel. It appears that they want to have a mistrial in this case. At any time, they could have come to the court and asked for a ruling. Instead, they rooted through attorney-client privilege materials, work product materials, and then put them before the jury and said to Mr. Jones on the stand, that's how I know you lied to me. Your attorneys screwed up and sent this to me. That is grounds for a mistrial, Your Honor. And that's why, in addition to the request that they delete the information from their servers and delete the link, we're also requesting at this point, unfortunately, a mistrial.
Sure. Let's correct all of that, Your Honor. First, let me just go through the facts that they were said. This link of materials was sent to me. It was sent to Mr. Ogden. It was sent by Mr. Reynolds' legal assistant, also to Mr. Reynolds, also to Mr. Magliola. Okay. As I informed Mr. Reynolds, we started downloading those materials. I was busy on trial prep. I told my paralegal, get these on our server, download everything there. All right. A little bit after he gets this stuff downloading, it's like, wait a second, this file that we now have on our server has clogged up our entire server. It's like 300 gigs. What's going on? So at that point, which again, materials in my possession at that moment. At that point, I notified Mr. Reynolds and under Rule 193.3 about inadvertent production. All right. It's funny to me that in this motion, Mr. Reynolds actually block quotes 193.3 to you. So I know he knows how to read it, but he still hasn't. At the moment he is up here requesting a mistrial, as he hasn't followed the rule. Even today, late has not followed the rule. The rule requires that production is, any privilege is waived. Any privilege is waived if within 10 days, or if you order a shorter time, but within 10 days, the producing party of when they actually discover, so 10 days from the moment I told them, that they identify specifically the material or information produced and state the privilege asserted. I have not heard any privilege. I've never heard a privilege asserted over any document. I certainly have not had specific documents identified and what their privilege is. If that happens, and he does identify specific material or information, we must return the specified material information while the court rules on the privilege. None of that has happened. What's interesting to me is this is not the first time that materials like this have been inadvertently produced in this case. As you may remember from prior hearings, Mr. Barnes inadvertently produced materials. Now, in that case, some of that information ended up coming out. They ended up letting me keep some of it, and we ended up talking about it. But there were attorney-client communications in there, which you don't know about, which I do, which they did follow 193.3. And they did identify those by page number, said here is the privilege. And when that happened, I promptly returned them and destroyed all my copies. Mr. Reynolds is right now using a fig leaf of this motion to say I violated, to put a fig leaf over his own malpractice, over his own absolute breach of his duties to his own client. And he's attempting to put that on me and doing it in front of a televised audience. That's what he's trying to do. So we have that first issue, which is the privilege. That privilege is waived. And at 10 days, I was not required to get a ruling on it. The only time I'm required to get any ruling is when privilege is asserted. And it has never been asserted. Could have even been asserted this morning. He might have come in here and said, Your Honor, I know I'm 3 days late, but can you please still hear me? And maybe we'd even be hearing it. But right now, it's so frivolous that we haven't even determined privilege. The second part I want to talk about is that Mr. Reynolds says in his email, please disregard. Please disregard creates no legal duty on me whatsoever. None. Mr. Reynolds should know this if he's going to come in and try to protect his client's information. And he does know this because, again, he quotes the books. He says that I will work on preparing you a new link. In other words, the idea here, Your Honor, because I don't think this is true, but the idea was that what he was wanting to provide to me was actually some maybe, I guess, last minute supplemental production, right, before this trial, days before this trial. I don't think that's what was happening. And the reason I don't think that was happening is because Mr. Reynal never worked on preparing me a new one. He never ended up sitting me and going, here is the correct materials. Instead, he went to trial and waited until after his client got off the stand and now says, oh, well, I meant to send him more materials. So what we're basically hearing is that Mr. Reynal, at that point, if his story is true, knew that he was supposed to supplement his discovery, knew he was supposed to provide those materials to me. And when I alerted him that he failed to do that and provided me something else, he just ignored it. Decided I'm not going to supplement discovery. So if that's true, if that story is true, we have a willful violation of discovery by Mr. Reynal to allow this case to go to trial with documents that he says he needed to provide to me. That in and of itself is essential. That's not the real story of what happened. It's just not. We know what happened here. Norm Pattis up in Connecticut was passing his file along to Mr. Reynal. And I know that because the directories contain like SharePoint OneDrive backups of Norm Pattis' computer. He's providing it to Mr. Reynal. And that, Your Honor, is also independently very troubling. Because Mr. Reynal talks about these medical records. That's what he's concerned about, is these medical records. Well, one thing I can tell you right now, Your Honor, is when I figured out that I had confidential psychiatric records of all 9 Lafferty plaintiffs and their confidential depositions, I immediately destroyed them. And I told Chris Maddy, plaintiff's lawyer up there, that I've done that. He is on notice that those materials are not in my possession. But I told him, look, I trust my staff. They're good people. And I trust that those materials will never leak. But nonetheless, that is a significant data breach against his clients. And what's most concerning is that Mr. Reynal has not yet made an appearance in the Lafferty case. Mr. Reynal is not allowed to have those documents. Mr. Magliolo is sure not allowed to have the documents of the psychiatric medical records of those Lafferty cases. Second is confidentiality. The defendant's motion attempts to say that I have somehow violated the spirit of the confidentiality order in this case. The confidentiality order in this case provides a method that if a party believes that it has inadvertently produced confidential material, it should be designated confidential. What it must do is specifically identify those documents, provide new copies of those documents with the confidential mark that is required under the protective order. To date, Mr. Reynal has still not done it. And it would be impossible for him to do so because the vast, overwhelming majority of the things contained on Mr. Jones' cell phone are not confidential. Mr. Jones it probably would have behooved Mr. Reynal to know that if he had produced me those text messages about the financial, he probably should have designated those as confidential. Not doing so was probably a serious and actionable breach against his client's duties. But even more important than that is all of the stuff in there. He cannot now come into court and claim 2.3 gigabytes of phone material, blanket designation of confidentiality. The protective order prohibits that. You must identify specifically the documents that are. And things like Mr. Jones and his intimate messages with Roger Stone are not confidential. They are not trade secrets. None of them. There's been no protection ever asserted over these documents. And frankly, Your Honor, I think you realize that this is not the first time that defendants have come into this court with a frivolous motion accusing me of misconduct over the handling of confidential materials. Pre-trial, we dealt with this exact same issue where they tried to claim that the release of Mr. Jones' third deposition was a violation of confidentiality. Again, they asked you for the same thing. They asked you to dismiss the case last time. And in that, we proved that they weren't up to speed. They didn't know that it had already happened 2 times, completely consistent with the protective order. For right now, I can tell you, Your Honor, I have, as I've told you, there are people interested in watching this right now. I am under request from various federal agencies and law enforcement to provide that. Absent a ruling from you saying you cannot do that, Mr. Banks, I intend to do so immediately following this. I believe that there is absolutely nothing that Mr. Reynal has done to fulfill his obligations to protect his client and prevent me from doing that. I believe that what we saw yesterday on the stand is not a basis for any mistrial. Mr. Reynal certainly cited us no Walter. This is the facts of what happened, and Mr. Jones was questioned if he understood those facts. That's all that happened. That's the other big problem. There was no contemporaneous objection to any of this, of course. Literally sat through it and stood mute during the entire time. The other problem, Your Honor, is that we have Mr. Reynal now asking you to seal up an entire universe of things which should have been produced at minimum 6 months ago. One of the things you also, I know you remember, is that for multiple prior discovery hearings, beginning as early as October of last year, we've been talking about text messages every single hearing. And then you remember we had that hearing in January where we had the disclosure that, wait a second, Don Salazar, or no, Nico Acosta, the producer up in Connecticut, had produced some text messages up there that seemed to be responsive, should have been on Rob Dew's phone, Alex Jones' phone. Why don't we have them? What's going on? And you'll remember in those series of hearings, right, when Mr. Reynal came here in March and told you, no, those were only on Mr. Acosta's phone. Mr. Jones, we've searched his phone. He doesn't have text messages that are responsive. So again, not only is this a fig leaf to cover up the things he has broken with his client, this is a fig leaf to cover up the fact that he had been misrepresenting to you for months, telling you that these things did not exist. Under these circumstances, not only do I believe that this motion that's being brought is frivolous, plaintiffs believe it is downright perverse. We ask you to know.
Yes, Your Honor. I think it's instructive to actually look at the text of the email that Mr. Bankston sent to me, where he says that he was downloading the material, but he wanted to verify with me that he needed to download it all. Right? That is immediately contrary to what Mr. Bankston is saying now, which is that all the materials have been downloaded by the time he sent me that text. Beyond that, it also appears that Mr. Bankston once more is performing for a national audience. The text messages that were provided, what he refers to as Mr. Jones's phone, based on my review of what was produced, it's not in there. Okay, and what was in there was a review copy of text messages from a 6-month period between, August of 2019 and the first quarter of 2020. So this allegations about law enforcement interest and stuff like that is just absolutely calculated to create more press around this issue. This never should have gotten this far. When I told him, please disregard the land, that should have been enough.
Okay. I think, lawyers get accused of relying on technicalities, but your concluding argument essentially asks me to rely on the technicalities of Mr. Bankston's language in his email. His counter argument asks me to rely on the technicalities of your language in your responsive email and in the orders. I think that's the safest way to go. So I don't think that you have complied with the protective order. I will let you do so now if there are documents and you would like to mark them as confidential, and we can go through the process and I can review them and make a decision, but I'm not going to seal the entire quantity of information without knowing what's in it when the rules weren't followed properly. Medical information, I think I heard you tell me it's already been destroyed. If that's not true, I will order that, because I don't think the medical information of any individual who's not a party to this case is relevant in any way, shape, or form to this case. So that I can do easily. The rest of it really depends on what's in there and circumstances and the rest of it. I don't think it's a mistrial based on this.
I understand.
Do you want to make more? I mean, that was kind of a throwaway. I don't know if you really meant it.
May I have 10 days from yesterday to comply with the rule?
Well, I don't know, because we're going to have another part of this trial. I think you should try to work on it today. See what you can get done.
It's a tremendous amount of information, John.
I know. The problem is it probably should have been disclosed a year ago or longer. And then there would have been plenty of time to look through all of it.
I understand. I mean, some of the things we're talking about are core attorney-client privilege. I mean, emails and text messages back and forth with lawyers. I'd just like a little bit more time to look.
Well,
for
I'm
the-
not saying you can't have more time. I'm saying I'm not going to treat it as confidential until you get it, your review done. You can make you can mark documents confidential late some reasonable amount of time. If I have to come up with a certain number of days, I will. But I don't know that I'm gonna say they can't use anything. We can talk about it before it gets used.
Can we have a hold on disclosure for some brief period of time until I can start marking documents? Because if not, the cat's out of the bag. Your Honor.
Well, I don't know. What is your intention to do?
I've been asked to turn them over today. I certainly intend to do that unless you tell me not to. I don't see how the protective order can be applied in a way that would prevent me from doing that. I think they've dropped the ball completely. So
Turned it over to authorities, turned it over to, who are you turning it over to? Are you
Right now,
allowed to say?
I've been asked by the January 6th committee to turn the
I mean,
document
I don't
over.
know that you get to stop that anyway.
Well, if they subpoenaed them, it would be a very different story.
Well, they're going to now. They know about them. They know they exist. They know you have them. I think they're going there either way.
Can we wait until
The
they
other-
actually do it, Your Honor?
I don't know about that.
The other party, which I believe there's no way to stop this in any way through this confidentiality arguments, is obviously the plaintiff's counsel in Mashpee would like the materials as well. There is a sharing provision in our protective order that I'm allowed to share confidential and attorney-as on the information with them. At the moment, they're not confidential, right? So I can share them with them regardless. But even if they were designated confidential at a later date, or if there was a hold right now, that they wouldn't be outside the protective order.
Right.
So I can give it to them. At this moment, that's the only disclosures I plan to make. So those two, I don't feel there being a reason to stop.
Did you know about those planned disclosures before this hearing, Mr. Raynold?
No.
Okay, well, you can have a little bit of time while we're waiting to research whether there is some reason I should not allow Mr. Mason to make those two disclosures. All right, I think that you didn't tell me if you really are trying to move from this trial, or that was just a throwaway.
No, we are moving from this trial.
It's like the 17th time or something. Based on just the exchange between Mr. Bankston and Mr. Jones yesterday on the stand.
And obviously, Mr. Bankston has been rooting around in the attorney-client communications.
I think that overstates circumstances. First of all, you and Mr. Bankston have been here with me what feels like 24 hours a day for 2 weeks. So I don't know how he has been doing any of that, number one. And number two, it sounds like an enormous quantity of material. The only thing I've seen is one text, one text. So I don't know what organization this material is in. I don't know if it's labeled or if he did a search. I don't know, and you don't know whether he's seen anything attorney-client privileged or not. So I don't think you should say that as if it were established. I'm gonna deny the motion.
Thank you.
All right, I think that concludes the hearing.
Thank you, Your Honor.
Thank you. You, camera. You can rub me.
May I be excused?
Yes, you're all.